Let's take a look at a key case within the criminal law. This is the case of R v Kimsey, heard in 1996, and this is the legal authority upon the topic of legal causation. Let's take a look at the case facts. In this case, the defendant and victim were involved in a high-speed car chase, which ultimately led to the death of the victim. The prosecution and the defence had varying accounts about the specific order of events that had taken place. It was not disputed that the victim had been struck by a third-party car and was killed as a result. What was disputed was what led to the victim being hit by the third car. The prosecution alleged that the defendant had overtaken the victim and struck the victim, which then caused her to lose control, be struck by another car and killed. The defence case was that the victim had lost control of her car herself. She then struck the defendant, and she was then subsequently hit by the third-party car and killed. The defendant was convicted of causing death by dangerous driving and sought to appeal upon the basis of the direction that was given by the trial judge at the trial upon the issue of causation. The jury posed many questions upon the topic of causation, upon what had to be proved, and did it have to be proved that the defendant was the cause or a cause of the result. The trial judge directed the jury that in order to prove causation, more specifically legal causation, the defendant didn't have to be the principal, only, main, or substantial cause of the result. What must be proved is that there is more than a slight and trifling link between the defendant's actions and the outcome. The defendant sought to appeal upon the basis that this direction was a misdirection and therefore his conviction was unsafe. The outcome was that the appeal against the conviction was dismissed and the defendant was still found guilty. In the judgment, the court held as followed. Whilst juries are often advised that the defendant must be a substantial cause of the result for legal causation to be satisfied, that is not in fact essential. Legal causation does not require proof that the defendant was a principal or substantial cause of the result. It is an acceptable direction to tell a jury that as long as they are sure that the defendant's actions were a cause and there was something more than a slight or trifling link between the defendant's actions and the criminal consequence, legal causation is proved. R v Kimsey is therefore a defining case when it comes to legal causation and can be cited every time that legal causation is referred to within an exam question.